So we're going to talk today about the importance of judicial training in cybercrime and criminal evidence, particularly to providing this to judges, the magistrates, and the entire spectrum of judiciary. Well, this is very important because the Council of Europe Convention on Cybercrime through the CIPROC office has been delivering training and continues to deliver training on cybercrime and electronic evidence to a whole host of actors, what I like to call the criminal justice process. And the entire criminal justice process chain requires not only training to judges, it requires training to prosecutors, forensic experts, investigators, and of course also judges. The reason why this is important is because you want to make sure there's a full spectrum of training provided to the entire process within the justice system. The importance of making sure that judges understand this is because the judges are going to be important in the process of understanding how new specialized investigative powers and new specialized means by which evidence is tested in court, either it's produced, grounds are argued about, or judgments are rendered, will require a certain basic understanding of both the nature of cybercrime and electronic evidence and how it is proved and submitted to court. So this is very important for judges to understand. If this is not available, what tends to happen is that either you have a situation where judges can be overly liberal, which means it is dangerous for civil liberties and safeguards, for protecting the rights of the citizen, to ensure that things are not being done by investigative agencies, etc., which are not controlled by independent judicial supervision. Or the result could be that there could be overly conservative responses from the judiciary, which is that there's a denial or rejection of many of the investigative requests that could be made by prosecutors or by the police. And that would lead to a situation where it's dangerous for the victims because it creates an environment where you cannot go after the criminals and bring them to justice. So it's important to keep a balance in the justice arena to make sure that the judges understand the importance of specialized investigative powers, asking the right questions, making sure they know enough about how they can query the prosecutors and the various investigators who come before them in ensuring that the judgment that they pass or the order that they issue or any investigative power that they authorize is being done after having scrutinized the circumstance of the case based on some degree of technical knowledge and understanding about the special nature of the investigative power and evidence involved.
Lawful collection and use of the electronic evidence is a crucial issue in the world, and still the world criminal justice authorities discussing these issues. Because in one side there is interest of justice, and on the other side there is human rights, which include privacy, family privacy, and human dignity, freedom of expression, freedom of thought, etc. When collecting or ordering the collection of these digital evidences, I think the law enforcement officials and the criminal justice system should establish an excellent balance between the human rights and the interest of the justice, and moreover they should give a particular importance to the proportionality. How the law enforcement officials should collect the evidences and how they implement the warrant, because warrant sometimes says you have to go make a search, sometimes says you search and seize. So they should keep the border of the warrant. Otherwise it will be infringement of privacy, freedom of expression, freedom of thought, and breaching of personal data, etc. So it is important how they act also in the premises of the victim or accused. They should only focus on what the order said to them. Otherwise, they might breach their rights again. These are all the questions has been discussed by the old world criminal justice systems. Although European Court of Human Rights has plenty of judgments and decisions and the case law outlining, set out the principles of this problem, but it is not enough when we come to the area of the international legislations. We have Budapest Convention and some other conventions and many regulations from the world institutions. But because the cybercrime is improving, evolving and developing expeditiously, sometimes the international instruments are not enough to answer to this problem. So criminal justice systems in the world should be able to respond to the question as expeditiously as cybercrimes.